Hey everyone, welcome back. This is Angela, and you're listening to the Study for the Bar in Your Car podcast. So this is season 2, where we are tackling contracts. And this podcast that we're doing now is specifically on contract formation. Now, contract formation is such a big topic, and it's so fundamental to the bar. Like, they really, really test you on this on the bar exam. So I've broken this up into 3 different podcasts just on contract formation. So this podcast is really going to be on mutual assent, and we're going to sort of delve a little bit into the other areas as well. But this is the mutual assent part of contract formation. Anyhow, as I was saying in the previous podcast, contract law is one of the legal topics that I think took me a while to grasp. And it took, I don't know, it just took me, I feel like it took me years to really understand it thoroughly. And it's the only exam I took in law school, at least the first time I went to law school. So I went to law school in the UK. And contracts, like I failed the contract exam twice and I had to redo it. And basically, if you fail 3 times, you're out of the program at all. And I was on a full scholarship, so I'm like, I cannot fail this. But I found contract law so difficult to wrestle with. And even when you're in the UK, you don't have they don't have the UCC over there, but they have all these other statutory laws. But it's just as difficult over here as it is over there. So, but I feel like I finally have become friends with contract law, and now I actually kind of like it. Whereas before I would just dread it because the ideas in contract law seem so conceptual. Like it seemed like, whether or not there has been a meeting of minds, it was really difficult for me to grasp. But now I have, and I like it. And one thing I like about it is just because the rules are very plain for contract law. I don't know, when I get a contract law MEE or essay, I get excited about it because I feel like I can nail it. Anyhow, that didn't happen overnight. It took me years and years to wrestle with, but sometimes we don't have years and years, especially if we're pressed to take the bar exam. Anyhow, so if you need to reach me, you can reach me regarding this podcast at podcast@studyforthebarinyourcar.com. But if you would like to hire me, so I'm a law clerk. I work freelance for attorneys across the globe, mostly in the United States, but sometimes in the UK as well. And I do ad hoc law clerk work. So if you want to hire me, you can reach me at hello@legalwriterandlawclerk.com. Anyhow, without further ado, here are our AI host, Claude and Maud.
All right, everyone, buckle up for a special contracts deep dive, custom built to really supercharge your bar prep.
Yeah, get ready.
Think of this as round 2, maybe, of our Study for the Bar in Your Car series. And it's all thanks to Angela, a fellow law student over at GMU.
That's right. She shared her study materials, which is fantastic.
Really generous. So our mission today, we want to make the bedrock principles of contract formation, crystal clear.
And hopefully unforgettable as you gear for the exam.
Exactly.
Today, we're really dissecting how a contract, how it actually takes shape. We'll zero in on mutual assent, that crucial meeting of the minds.
Right, the agreement part.
Yeah, exploring the whole dance of offer and acceptance. We'll also map out the different flavors of contracts based on how they come together.
Like unilateral, bilateral.
Exactly, unilateral, bilateral, and those sometimes less obvious implied in fact agreements.
Okay.
And finally, we'll try to demystify indefiniteness and what happens when, key pieces of the puzzle seem to be missing.
Consider this your essential guide, maybe, to laying a rock-solid foundation in contract law.
Couldn't have said it better.
Okay, so let's dive straight into the very first piece of that puzzle, the offer. What transforms a communication into a valid offer?
Well, according to Angela's notes, it's basically about the offerer showing a clear willingness A willingness to enter into a deal on specific terms.
And it's objective, right? Not what they were thinking secretly.
Precisely. This isn't about secret intentions swirling around in someone's head. It's judged by how a reasonable person on the receiving end, in the offeree's shoes, would understand those words or actions.
It's what's put out there that counts.
It is. And what's interesting, as Angela's outlines highlight, is that for an offer to be valid, it needs, well, a few key ingredients.
Okay, like what?
First, it has to be reasonably certain in its terms. We'll talk more about that. Second, it absolutely must be communicated to the offeree.
Can't accept something you don't know about.
Exactly. You can't accept an offer you don't know about. And third, it can't have already been terminated somehow before acceptance.
Okay, so reasonably certain, what does that usually mean?
Well, Angela's notes tell us that usually means you can identify who the parties are, what exactly they're contracting about the subject matter, and there's a price term involved.
Or at least a way to figure out the price.
Or at least a clear way to calculate it, yeah.
Angela's written notes, they really nail this down with a perfect example, I thought.
Oh, yeah. Which one?
She describes a car salesperson saying, "Would you be willing to pay me $450 for this beauty?" while pointing directly at a specific car on the lot.
Ah, right. That's a good one.
That's a valid offer. Why? Because it's crystal clear who's involved, the salesperson, me, and the potential buyer,
Right.
you.
Well,
It unambiguously identifies what's being offered that specific car, and it spells out the price. Simple, effective.
precisely. And thinking about, potential bar exam traps, it's really vital to distinguish what isn't an offer.
Right, because not everything is an offer.
Not at all. Angela's notes are very clear that not every communication is a proposal for a binding agreement. To be an offer, the communication needs to contain a genuine promise, like a real commitment to actually enter into a contract.
Not just testing the waters.
Exactly, rather than just an invitation to start negotiations. So phrases like, "I'm quoting you," or "I'm asking $30 for this item," or even, "I might consider selling for."
Those sound more like opening bids.
Generally, yeah. They're seen as those initial invitations to deal, not actual offers that you can just say yes to and form a contract.
Okay. And Angela's materials also touch on a really important aspect. How an offer can, well, die. How it gets terminated.
Oh, right, termination.
One key way she points out is the destruction of the very thing being offered, the subject matter.
Yeah, that's a straightforward one.
Picture this. Someone offers to sell you their vintage motorcycle, right? But before you can even say yes, I don't know, a robe tree falls on it.
Oh, no.
And it's totaled. That offer is automatically dead. Poof.
Can't accept it anymore.
It can't be accepted because the subject of the offer, the motorcycle, well, it no longer exists. Makes sense.
It does, absolutely.
Okay.
Okay, so now let's say we have a valid offer hanging in the air. It hasn't been terminated. What exactly constitutes acceptance?
How do you say yes properly?
Basically, yeah. Angela's outlines explain that acceptance is the offeree's way of demonstrating their agreement, their assent, to the terms of that specific offer.
And like the offer, it's objective, too.
Exactly like the offer. Acceptance is also judged from an objective standpoint. How would a reasonable offerer interpret what the offeree said or did?
Okay. Angela's notes detail the general rule, the mirror image rule.
That's the one. Acceptance has to be a mirror image of the offer. If the offeree tries to change any of the terms.
Even a small one.
Usually, yeah. Any change to the terms generally constitutes a counteroffer, which, importantly, rejects the original offer.
So it kills the first offer.
It does. So you can't respond to that $450 car offer by saying, "I'll give you $400, and expect that to be an acceptance of the original $450 offer. Nope, that's a whole new ballgame. You just made a new offer.
Precisely. But here's a critical nuance, especially important for, bar exam questions involving the sale of goods under the UCC.
Ah, the Uniform Commercial Code. Always got to watch for that.
Always. Angela's written notes clarify this. If a buyer orders a specific quantity of goods, say 12 kayaks,
Okay.
and the seller ships a different quantity, maybe they only have 10 in stock, that shipment can actually still be considered an acceptance.
Wait, even though it's not the right amount?
Yes. It creates a contract for the goods that were shipped. It's treated as an acceptance of the offer up to the quantity shipped.
Okay, so a contract for 10 kayaks.
Right, but, and this is key, it's also treated as a breach of contract for not sending the full amount ordered, the missing 2.
Ah, so it's acceptance and breach. Interesting.
Yeah, it's a common scenario, like Angela's example. An outdoor adventure company orders 12 bright yellow kayaks, the manufacturer only has 10, ships those 10. That's generally seen as acceptance for the 10.
And a breach for the other 2.
Got it.
Okay, now Angela's outlines also delve into unilateral contracts.
Where acceptance is doing something, not promising something?
Exactly. Acceptance isn't about a return promise. It happens by actually performing the offer requests. Think reward for lost dog.
Right. Finding the dog is the acceptance.
Precisely. And the examples in her materials illustrate that once the offeree starts to perform in a unilateral contract,
Like they start looking for the dog.
right, once they begin performance, the offeror's ability to just revoke the offer is limited. They generally have to give the offeree a reasonable time to finish.
So they can't pull the rug out from under them halfway through.
Generally not, once performance has begun. However, and this is an important distinction, simply getting ready to perform.
Like buying a leash and dog treats.
Yeah, mere preparation usually doesn't trigger that protection. Performance itself needs to start.
Okay, that makes sense.
And what's really key to remember, as Angela's materials emphasize, is that the offerer is the master of their offer.
They set the rules.
They totally set the rules. They have the power to dictate the specific act that will count as valid acceptance.
So if they want acceptance via singing telegram,
Then only a singing telegram will do. Her example was, if someone offers to buy your antique record player and says, you can only accept this offer by waltzing into my office wearing a top hat
okay,
and singing Bohemian Rhapsody next Wednesday at noon, then and only then will that specific, possibly bizarre action count as acceptance.
wow. Okay, be specific.
And also, as Angela's notes remind us, you absolutely have to know about the offer to accept it.
Right, you can't accidentally accept.
You can't stumble into acceptance of an offer you had no idea existed. Knowledge is essential.
Got it. And one more important type of agreement Angela covers. Implied in fact contracts.
Ah, yes, the ones based on conduct.
Right. Here, the parties don't explicitly state their agreement in words, either written or spoken, but their conduct, their actions, clearly demonstrate they have an understanding.
Their behavior shows the deal.
Exactly. The terms of this kind of contract are those that their actions consistently point to. And sometimes, the UCC can step in to fill in any gaps, like a reasonable price if needed.
Think about maybe going to the same barber for years, sitting down, getting a haircut, paying the usual price. There's probably an implied in fact contract each time.
Even if you never explicitly say, I offer to pay for a haircut, and they say, I accept.
Right. The conduct speaks for itself. Okay, shifting gears slightly. Angela's outlines provide a really helpful breakdown of the different types of contracts based on how they are formed.
Okay, let's clarify those.
She clearly distinguishes between bilateral and unilateral contracts. As we sort of touched on, bilateral contracts are all about the exchange of promises.
A promise for a promise. I promise to paint your house if you promise to pay me.
Exactly. That's the classic bilateral setup. Unilateral contracts, on the other hand, involve a promise from one party that is accepted by the other party's action or performance.
Promise for an act, like the lost dog reward.
Perfect example again. And Angela's notes highlight that in modern contract law, the presumption or the preference is generally that most contracts are treated as bilateral if possible.
Why is that?
Well, it protects both parties sooner once the promises are exchanged, rather than having to wait for performance to be completed.
Makes sense. Angela's materials also briefly touch on express contracts, right?
Yep, express contracts are probably what most people think of the terms are explicitly spelled out, either verbally or in writing. Very clear.
And then she mentions quasi-contracts, implied in law.
Ah, yes. Quasi-contracts. It's really important to remember, as Angela's notes explain, that these aren't actually true contracts. There's no real agreement.
So what are they then?
They're legal remedies. Fictions created by courts, really, to prevent unjust enrichment.
Unjust enrichment, meaning someone getting a benefit they didn't fairly pay for.
Exactly. Situations where one party would unfairly benefit at the expense of another if there were no legal recourse. Think maybe a doctor providing emergency care to an unconscious person. There's no contract, but the doctor can usually recover a reasonable fee to prevent the patient from being unjustly enriched by the life-saving service.
Gotcha. It's about fairness, not agreement.
Precisely. Okay, now for a fundamental principle in contract formation, one that Angela really underscores in her materials, the requirement that the terms of the contract must be reasonably certain.
Things can't be too vague.
Right. If the terms are too indefinite, too vague, a court may not recognize a legally binding contract at all.
Why not?
Because, as Angela's notes explain, for terms to be considered reasonably certain, they need to provide a clear enough basis for a court to figure out two things. One, if a breach has actually occurred, and two, how to fashion an appropriate remedy if it has.
So the court needs something concrete to work with.
Exactly. It prevents courts from having to essentially guess what the parties intended, or worse, write the contract for them after the fact.
Okay. Angela's outlines specifically point out that for the sale of goods under the UCC, a quantity term is generally required, right?
Generally, yes. You usually need to know how much of a particular item is being bought and sold. That's pretty fundamental.
But there are exceptions.
There are. Angela's written notes also introduce the concepts of requirements and output contracts. These are interesting.
How do those work without a specific number?
Well, in these types of agreements, the exact quantity isn't a fixed number. Instead, it's tied to either the buyer's actual requirements, how much they need, or the seller's actual output, how much they produce.
Like, I'll buy all the widgets I need for my factory from you this year.
Exactly. Or I'll sell you all the widgets my factory produces this year. What's interesting is that these can still be considered sufficiently definite.
Even without a number. How?
Because the quantity, while not fixed up front, can be objectively determined by looking at the buyer's good faith needs or the seller's good faith production. It's tied to real-world factors.
Okay, but there must be limits, right? You can't just suddenly need 10 times more.
Good point. Angela's notes do caution that under the UCC, in these kinds of contracts, requirements and output, the quantity demanded or offered, can't be unreasonably disproportionate to any stated estimate, if there was one, or to any normal or otherwise comparable prior output or requirements.
So you have to act in good faith based on usual levels.
Basically, yeah. You can't exploit the contract just because market prices change dramatically.
Makes sense. Now, what happens when certain terms are just missing? Like, they forgot to put in the delivery date.
That happens. Angela's notes address this too. The general principle, especially under Article 2 of the UCC for goods, is that if the evidence suggests the parties genuinely intended to form a contract.
They meant to have a deal.
Right. They intended a deal, and there's a reasonably certain basis for a court to provide a remedy, then the court may step in and supply reasonable missing terms.
Like a reasonable delivery time or a reasonable price if it wasn't set.
Exactly. Things like time for performance, place of delivery, even price in some UCC cases can potentially be filled in by the court using a reasonableness standard based on context, trade usage, etc.
But it's not automatic.
Definitely not. And Angela's outlines wisely note that the more terms that are left open, especially really essential ones, the less likely it is that a court will conclude the parties actually had the necessary intent to form a binding agreement in the first place.
So too many gaps might mean no contract at all.
It suggests they were maybe still negotiating. There's a point where too much is missing for a court to confidently fill in the blanks, consistent with what the parties might have wanted.
Okay. And Angela's materials also highlight a specific issue. What if they explicitly say, we'll agree on the price later?
The agreement to agree. That can be problematic. If a truly material term, like price in many non-UCC contexts, is explicitly left to be agreed upon at a future date, that can render the initial agreement too uncertain to be enforced.
So leaving it open on purpose is risky.
It can be. In those situations, courts might be hesitant to just supply a reasonable term because the parties themselves indicated they needed to reach a specific agreement on it later. Although, again, Article 2 does provide some exceptions, particularly for price terms in sale of goods contracts, if the other evidence strongly shows they intended to be bound despite the open price term.
It seems like the UCC is often more willing to find a contract.
Generally speaking, yes, Article 2 is designed to facilitate commerce and often tries to uphold agreements if the party's intent is clear, even with some missing terms.
Okay, one final point from Angela's notes on certainty.
What's that?
It emphasizes that the contract itself, as it exists after the offer and acceptance are done, must have definite and certain terms.
Right. The final agreement needs clarity.
So even if an initial offer might have seemed a bit vague, maybe lacking some detail, if the acceptance clarifies those terms, or maybe if the parties start performing and their actions make the terms clear,
then that can cure the initial uncertainty.
Exactly. It's about the final state of the agreement being sufficiently clear for a court to understand and enforce.
That's a great summary point. It's the overall picture.
So, as we've seen, really digging through Angela's comprehensive notes and outlines, the formation of a contract is, well, it's a multifaceted process, isn't it?
It definitely is. Not always simple.
It demands a clear offer, an unambiguous acceptance of those exact terms, that mirror image idea usually,
Right.
and terms that are defined with reasonable certainty.
Absolutely.
Yeah.
Grasping these distinctions, like between bilateral and unilateral, or understanding the pitfalls of indefiniteness, these are just foundational.
Foundational for your success on the bar exam for sure.
No doubt about it. Take a moment, maybe after this, to reflect on the examples we've explored today, all drawn from Angela's hard work.
Yeah, think about that car offer or the kayak shipment.
Exactly. Consider how these principles might play out in different hypotheticals, different fact patterns you might encounter on the bar.
What questions do these core concepts raise for you as you keep studying?
We really hope this focused deep dive, built upon Angela's generous sharing, has provided you with some valuable insights.
And hopefully a more solid, clear understanding of contract formation.
Keep exploring these vital concepts, keep practicing, and we're all wishing you the very best as you prepare for the bar.
Absolutely. Good luck, everyone.
Hey, it's Angela. I'm back. I would like to make a quick correction. I mentioned earlier that contract formation is so large that I'm breaking it into 3 separate podcasts. It's actually 2 separate podcasts. So this was mostly on mutual assent. And then we have another contract formation episode, which is next, which is specifically on consideration. So that's about it. I don't think I have anything else to say now. If you do need to reach me, you can email me, podcast@studyforthebarinyourcar.com. Thanks a lot, and we'll see you on the next episode.